you don't know anything about my business, you're in law enforcement, you're the person who, when they do something wrong, you're the last person they want to see. You live a very, very difficult but ultimately very narrow life. I believe, hang on, let me finish it a little bit. Well, it all goes, I think we've got like three or four pages, so I think it all kind of goes together. Hang on just a second. Okay, so this part, I mean, the part at the bottom of 18, it puts in context the part at the top of 19, and this goes directly to...
Right out of the gate, the defense is trying to establish something incredibly important in any criminal trial. Motive. Not motive for the alleged act itself, but motive to lie afterward. That's a subtle distinction that can have a huge impact on how jurors evaluate credibility. And notice the strategy here. They're connecting Baldwin's age, career, and public reputation to the argument that he had too much at stake to admit certain facts. The question is, will the jury see this as a reasonable inference or an unfair leap?
Mr. Baldwin's motivation to lie about pulling the trigger of the gun. I'm 63 years old with 6 kids. I can't rely on luck anymore. He's talking about his career and that he can't rely on luck anymore. This goes exactly to his motivation not to tell the truth.
May sound like a routine courtroom ruling, but it's actually a significant moment.
Sure.
The judge is essentially saying, because the redactions came in late, the material is coming in. This is a reminder that trials aren't just about facts. They're also about procedure. Miss a deadline or make a late objection. And evidence that might otherwise be excluded can end up in front of the jury.
I don't think this information is that helpful one way or the other, but I'm going to let it in because of the lateness of your redactions. So, because it's 2 o'clock now, and so we're going to go. All right?
I understand. May I just briefly be heard on that point?
No. All right. Get your redactions in earlier.
Understood, Your Honor.
And that includes 20 minutes.
Everything I quit on is coming in. Do you understand? That page forward
Yes.
So everything subsequent to.
and that page.
Okay.
Now watch the tone shift. The defense has moved away from arguing over documents and is focusing on something jurors naturally connect with: human behavior. They're about to revisit what Baldwin looked like and how he acted immediately after the shooting. Why? Because emotional reactions can shape perceptions of intent, knowledge, and credibility.
No, I know. He hasn't passed. We're asking two different questions.
Listen carefully to this testimony. The witness describes Baldwin as visibly upset and shaking. The defense wants the jury to picture the real-time aftermath rather than the defendant sitting calmly in court today. That's a common courtroom strategy. Contrast the polished courtroom image with the raw, emotional moments that occurred when the event actually happened.
And this goes on the record.
Did you ask for us to come up?
Yes.
I just, okay.
This exchange is more important than it might seem. The defense is highlighting actions that could be interpreted as cooperation with investigators, pointing officers toward evidence and sharing information immediately. Jurors often pay close attention to post-incident behavior. Does it look like someone trying to help uncover the truth, or does it not tell us much at all? That's a question every juror will have to answer. And here's a technical point that could become a major talking point later. The defense asks about DNA testing on the hammer of the firearm, and the witness can't speak to the FBI's testing process. Cases involving forensic evidence often turn on what was tested, what wasn't tested, and why. If you're on the jury, would the absence of a specific test create reasonable doubt, or would you view it as insignificant compared to the rest of the evidence?
All right, you may be seated. Go ahead.
Thank
Mr.
you.
Spiro.
Good afternoon. You had seen when you were testifying earlier Mr. Baldwin in court today, correct?
Yes.
Okay. And this is the first time that you've seen him since, I believe, since the day that the incident occurred?
Correct.
And of course, you see him here as a defendant in a courtroom wearing a suit jacket. He wasn't dressed like that on the scene, right?
Right.
He was Harlan. Rust, and he had his actor costume on, right?
Yes.
And you actually took those clothes and tested them for blood, like you said before, right?
I did.
And he was shaking as you did that, was he not?
He seemed upset as I did that.
And of course, you remember that, right?
Yes,
And the lapel that you've reviewed has refreshed your memory.
correct.
And you know that he received a phone call from his friend Joel, the director who had been shot, and you used that information to then send officers to the hospital to retrieve the bullet, correct?
I believe we already had deputies at the hospital at that time.
But he told you that and told you that that would be something that he wanted you to do, right?
He indicated it was something he wanted law enforcement to do, but we were already making the necessary, we were already sending a deputy to the hospital to retrieve that.
And he told you that he pulled the gun out, he turned, and he just cocked the gun, right?
He did state that, yes.
He didn't say he pulled the trigger, right?
I don't recall him saying that.
And you never tested the hammer of that gun for DNA, did you?
I do not know the FBI lab's process for processing a firearm for DNA.